Good evening, everybody, and welcome to the Wednesday night live stream. This is Jonathan Ginsberg. I hope you are all doing well. Please also let me know in the comments you can hear me okay. You should be able to, but I always like to double check that because sometimes there are some issues with the audio, but hopefully that's not the case tonight. Before I start taking questions, I wanted just to kind of tell you all about a hearing I had today, and a couple of things I thought was kind of interesting about it. That might be applicable to your case or to a continuing review. And this case involved a gentleman. It was a good case. He was over 55 with some significant problems, both physical and mental. Judge is reasonable, has a pretty high approval rate. And, the hearing was going along fine. And the judge was really focusing a lot on the dates of treatment. And this gentleman was treating some at the VA, some private. But bottom line is, after he stopped working, he didn't really treat very much right away. It took a while before that treatment started to kick in, really almost a year. And the judge was really concerned about that because he felt like, this person stopped working. His conditions are not conditions that happen, just out of the blue. These are things that are long lasting, and we had evidence that they had been a lot of previous issues with it and complaints about things and even some treatment, but the really intensive treatment did not start for well over a year after the onset date. And so the judge ended up basically offering us an approval if we amended the onset date to when the treatment started. And actually he even gave me a little bit of leeway. I was able to get him to agree to an onset date before treatment started in earnest. It was really more of a diagnosis. The point I'm making is that when you apply for disability, judges and disability adjudicators are going to look at the dates of treatment. They're going to want to know when you started treating. So if you stopped working but didn't go to the doctor for 6 months or a year, that can be a problem. Now, again, some judges are going to recognize that, let's say if you have back issues, they don't typically just happen, on a Tuesday when you were fine Monday. Or if you have, knee problems, they don't just arise unless there's a traumatic event. They don't arise, one day out of the blue. But I think that, what this says to me is that Social Security is putting more emphasis on the treatment being consistent with the allegations. And this is true both in terms of the level of severity, meaning if you're saying I have severe back pain with radiation into my leg and numbness in my feet, then the objective evidence needs to be consistent with that. There needs to be an MRI that shows, nerve root impingement or some sort of stenosis, something like that. Similarly, if you're saying I have severe pain in my knees or my back or whatever, then, if you don't go to treatment, then Social Security assumes if you're not taking treatment, then there's nothing really wrong with you. So you got to be aware of that. And I think in the CDR context, continuing disability review, after you're approved, it's really important that you continue to treat with your doctor. You can't feel like, okay, I've been approved and now I don't have to do anything, because I suspect what we're going to start seeing is CDRs coming about, and they look at the medical record, they see that after your approval, you didn't go to the doctor. So again, the assumption is you're not going to the doctor, there's nothing wrong with you. They'll conclude medical improvement. So I think it's really important to see your doctor, and even if it's just reporting the problem on a regular basis, and certainly as soon as possible after onset and after you're approved, continue to see the doctor. And I realize money can be an issue, but just even if you go in once or twice a year or go to a free clinic, just reporting that there's a problem at least gives a judge who wants to approve a something to hang his hat on, because otherwise I think that Social Security is really pressuring these judges not to approve or to affirm a termination of benefits if there's not contemporaneous medical treatment and evidence along with the complaints. So I just thought that was a very interesting occurrence, and I haven't seen it as much before. Maybe this is a one-off with this judge, but I suspect that that's one of the things that they're telling the judges, is to make sure that this is all lining up, that the treatment is consistent with the allegations of pain or discomfort or inability to do things, and that you're getting treatment, the same time you're saying you can't work. You can't, not work and then sit at home for 6 months or 8 months. And again, I realize it can be a problem because you can't get an appointment. The VA may take 4 or 5 or 6 months to get an appointment, but maybe you go for telehealth, or maybe you go to an emergency clinic, but you have to be proactive about that. So I just thought that was an interesting occurrence, and I wanted to just make you aware of that, because I think that is going to become more of a trend as we move forward. Okay, let's jump into the questions. We have Wayne C., who is 54 years old. He's 7 months into the initial application, but unable to work for 10 months. He's given all the updated medical records, and he's gone through a consultative evaluation. He's got an upcoming fusion surgery and a lumbar appointment, an MRI for his lumbar. Wants a second opinion from a neurosurgeon about surgery. Also has a 35-year work history, mostly labor jobs, worried about the surgery. Well, first of all, under Social Security regulations or in their rulings, they are not allowed, Social Security is not allowed to punish you or to deny a claim or discount your claim because you choose not to undergo an invasive procedure like a fusion, multi-level fusion, or even something as kind of routine as an epidural. There's risk with any surgery, any kind of surgical procedure. And I think that if you have concerns about that, then it's okay. I think as long as you make those concerns clear and say why you're not doing that. I spoke to a new client today, about 2 hours ago, and this is a gentleman who's had 2 surgeries, and he said to me, they want to do a third, but I don't really want to do that because I think it's just the first 2 didn't work as well as we thought. I don't want to deal with this, just the issues with the surgery, the scar tissue, the pain, the narcotic pain medication, all that stuff. Is it a problem if I refuse the surgery, the third surgery they're talking about? It is not a problem. And, I've seen situations where people are surgical candidates. They choose not to undergo the surgery and they're referred to long-term pain management, and that's fine. So you do not have to, Wayne, do not have to have the surgery. Getting a second opinion, assuming the second opinion doctor says, yes, you're a surgical candidate, that's going to make your case stronger. At 54 with back issues, obviously the thing that jumps in my mind is the grid rules, the sedentary grid rules, which basically would say if you're limited to sedentary work, defined as standing and walking 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion, and you have no transferable skills because either there were no skills associated with your job or because of pain or medication side effects or depression or anything else that would make any skills that you have acquired non-transferable, then you would meet the grid rule. So definitely take a look at gridrules.net, my website about grid rules, because at 54, if you're limited to sedentary, no transferable skills, you've got a really, really strong chance. Let me also say this. You are 54. What I'm seeing judges do and Social Security do at times is they might approve you, but as of your 55th birthday, what they would do is say, well, we feel like, we can't say you're limited to sedentary, but we can definitely say you could do no more than light work, which is standing 6 hours a day, lifting 20 pounds on occasion. So we'll approve you as of your 55th birthday. Obviously, that cuts out a lot of past due benefits. You don't have to accept that. If they did that, you can still appeal it. And if you, in other words, if you got approved at the initial level or recon level, you could appeal the approval and say, no, my onset date should have been back when I was 54 and not cut out 8 months or a year or whatever it was. The risk is if you go to a hearing and you get a bad judge, you could be denied entirely, and then you owe money that they paid you. So you sort of have to take a risk there. I've done that several times where I've had clients, they change the onset date dramatically. It's a $30,000, $40,000 haircut if you take their admitted onset date. And I've discussed with my clients, said, look, I'll do whatever you want. My fee is not a consideration. This is all about what you think is best. $30,000 or $40,000 is worth rolling the dice. The 2 or 3 times I've done it in the past couple of years, it has worked out. The judges approved. Usually I think the risk is simply that they will just approve you as of the 55th birthday or as of that amended onset date. They're not going to deny you outright, although some judges might. But I think most of the time the risk is really you'll end up no better off than you were, or no worse off than you were. But the upside is that you could, put another $20,000 or $30,000 in your pocket. That is a decision that you have to make, and it's got to be based on, what the evidence shows, and if you've got an attorney, what your attorney feels about it. But just be aware at 54, that's one of those ages, 49 to 50, 54 to 55, and to a lesser degree, 59 to 60, where Social Security, in order to save money, is sort of trimming off some of that past due benefit. And it's maddening because, again, they make you make this very difficult decision of do you appeal an approval, essentially. But you got to make a decision what you want to do. But I think that 35-year work history works in your favor. Labor jobs, again, suggest very little in the way of transferable skills. You have not been out for a year. Normally, they, at the initial and recon, they're looking for people who've been out for a year, because otherwise they have to make a decision that you will likely be out for a year. And that's a judgment call that many adjudicators don't want to make. But nevertheless, I think, but what you're saying here, surgical candidate, long work history, that all lines up pretty well. Certainly as of 55, it's real strong. At 54, decently strong, but just be aware of that possibility that they may try to go after your onset date. Okay. Essay, we got a two-parter here. Application is in. First time at particular pain center. Looked at notes written that I was risk user of opiates and narcotics. I've never used them and told them so. I messaged them. They corrected it. This made me feel uneasy. They corrected, but I have no idea why this could have happened. So what Essay is saying is that he or she, I don't know what your gender is. I don't want to presume anything. Went to a pain center, and the pain center, the note was that there's concern about possible misuse of narcotics and opiates. And that could simply be because of their intake process. They may ask you questions about, have you ever, how often do you drink? Or, have you ever had the alcohol problems, or whatever I don't know what the criteria they have. And they put this in there. You've never had a problem with it. I think that all pain centers are very, very concerned about government regulations. Most pain doctors will make you sign a pain contract, pain medicine contract, where you agree that you will only, take medicine as prescribed. You won't resell your medicines. You won't go to another pain center, things like that, because there obviously has been a lot of abuse of pain medication. I think you did what you were supposed to do. You corrected it. You made it very clear, and which is actually a helpful thing that they were able to do, because I was talking to a client yesterday, I think, or 2 days ago, and he said that he was he'd gone to the doctor, and he was giving the doctor an example about something that would cause him pain. It's like, if I was to do yard work, blah, 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 that would cause me pain. Doctor puts in the record, claimant, patient says he does yard work. So he writes the doctor afterwards. He says, I didn't say I did yard work. I said, if I did yard work, this is what would likely happen. They wouldn't change it. So we're having him write a statement on Form 795 to basically clarify that and to get that in the record. So again, in this situation, if that's been corrected, what you might do, the other thing you might do, if it's corrected, it won't be in the record, but you can certainly write on the form SSA 795 that you've been to a pain center. They seem to be very concerned about people abusing narcotic pain medication. I made it very clear that I've never had an issue with that. I will never have an issue with that. But there seems to be a little bit of overzealousness in the way they're putting notes together, where they're suggesting that it might be a problem. I want to make it clear it has not been a problem. It will not be a problem. And I understand the concerns of pain clinics to avoid situations where people are misusing drugs. That is not the case with me, and I want to make that very clear. So you could add that to your record with Social Security. And again, there's nothing to say that you ever have abused narcotics, and simply putting that in there would make it clear as to what triggered you to write that you seem to feel that they're overzealous in expressing concerns about that kind of thing. And this may be something that they just do as a matter of course with everybody to protect themselves when government regulators come in and look at their patient files. So that may be what's going on, but I wouldn't worry about it too much, especially given that that you have never used them and you're not that you're not going to use them in any improper fashion. Sarah D. If my attorney sent in a request for my hearing last month, what are you seeing for scheduling? I mean, it's generally going to be 5 to 7 months. There's a certain amount of time. I don't remember if it's 90 or 180 days. I was 90 days, I think, that almost by law, they've got to give you can waive that, by the way. But I think that's what the law says. They've got to give 90 days notice. What's actually happening when you request a hearing is the file is electronically moved from the DAS or the state agency to Social Security. And when it goes there, the Social Security hearing office will number the records. Right now, before it goes over there, the records are like just a bunch of papers in a folder, if you can imagine that. They're identified by date, and we can look at them. I can look at them as part of somebody's electronic folder, but there's no number by them. Once it gets to the hearing office, the files are exhibited in sections A, B, C, D, E, and F. Section F being the medical records. So the medical record from ABC Hospital might be 14F, and it may be 98 pages. Then 15F might be records from a pain clinic, or 16F might be, could be a chiropractor, even though that's not an acceptable medical source. It would all be numbered. So when I do my brief, I will reference the specific page numbers of the exhibits. So if the judge wants to look at it, he or she can. In fact, in my hearing today, the one where the judge was very concerned about starting with treatment, he said to me, well, Mr. Ginsberg, where is the first physical therapy record? And we're looking at, VA records, which are just voluminous. So I've got my PDF, reader out there, which I can do searches on. So I immediately put in the search in real time, physical therapy. And, it came up when the first physical therapy record was. But, that's a tough thing to do because, these records can be very, very long. And when a judge says, what is the first date in a VA record, I'll do kind of and again, some of the service providers we use are now offering summaries. I used to do them manually, and now I'm kind of using the one we use is called Assure, and they've got a summary service where it'll summarize, but it usually gets the main medical issues, and I go through and update it, but didn't have the physical therapy notes marked by date, so I had to find it real quick. But nowadays with computers being as quick as they are, it wasn't a big problem. As it turned out, I was correct the first date of physical therapy. I was able to find it pretty quickly, and it ended up getting us a favorable decision, albeit with a admitted onset date. But bottom line is, Sarah, I would assume 5 to 7 months, which is better than 10 to 12 months at initial and recon. So there doesn't seem to be as much of a backlog with judges. I see what they're doing now is judges are being assigned where they're available. So, for example, I had a case. Client lives in Washington State, Spokane, I think it was Spokane, Washington, and the judge was in Kansas City. That's not uncommon. A hearing, today the judge was in a different state than my client. So they're finding judges when there's availability, and that way it gets the hearings a little bit faster because it's all done by telephone or video. So they can do that now, which is actually really a good thing. Okay, Lily says, a few weeks ago, after CEOs notified my case went for quality review, I'm over 60, initial app, are the stats and approval. Are there stats? What percentage of approval versus denial sent for quality review? Also, can step 4 and 5 happen during initial application or only after denial and appeal for reconsideration? All right, well, let me ask the first part of it is, I'm sure there are stats. They're not publicly available that I've seen. I suspect one could do a Freedom of Information Act to find them. But I think Generally speaking, if it's going to quality review, that's a positive sign because it says they're reviewing to make sure that the approval was correct. Social Security doesn't seem to have a lot of interest in doing quality review of denials to approve. So I think it's more likely that they're approving and they want to make sure that they've covered their bases there. But I don't have any stats for you. And steps 4 and 5 happen during initial application. If you're talking about the 5-step sequential evaluation process, yes, it has to. That's the requirement for Social Security, either at the adjudication level or the judge level. And the 5-step process is basically where they analyze a case. Step 1, question 1 is the person working? Question 2 or step 2 is the impairment serious, which basically is a fairly low bar, but you have to have a diagnosis or some evidence that there's a condition that exists. It can't simply be you decide that you have, depression or PTSD. It's got to have some basis in medical fact. Third stage or third step of the sequential process is do you meet a listing, which again, at the initial and recon is more likely you're going to meet a listing. If you do, obviously it stops. So I misspoke before. If you do, if you win at stage 3 because you meet a listing, they don't need to go to stage 4 and 5. So I was actually wrong when I said that before. And stage 4 would be, can you return to past relevant work? And stage 5, is there any other jobs that are available? So if you meet a listing, the presumption is that your functional capacity is so reduced you can't work. So they don't need to go to steps 4 and 5 if you meet a listing at step 3. So that would be an initial. So that's the answer to your question. But so again, I misspoke before. But yeah, if you meet a listing, you don't go to step 4 and 5. Okay, Tara Upshaw. Yes, we did get an approval on you early on. We got an administrative approval, which is very, very gratifying. I'm glad that happened, and we are thrilled that we were able to do it. And again, a lot of it is just making sure that the evidence is there, that the medical information is there, that the forms are filled out, and that everything that they are asking us for, we're providing for them. And I'm glad that it worked out. And thank you very much for tuning in and posting. That's much, much appreciated. Okay. Pricey Joy. Hello, Pricey Joy. Say I got a CDR in 2027, a doctor's record from 26. I seem to have made some improvements since I started. Seeing her very relative. They're going to go demand overpayment from when the note was written. Generally speaking, my experience has been if they move to term, first of all, I think you're getting ahead of yourself because there's no guarantee they're going to terminate. If they did, the termination would be as of the date they decide to terminate. They don't go back and say you are terminated, a prior date. Now, if you don't go to a hearing, if the state agency level, they decide, okay, a Pricey Joy is no longer disabled as of March of 2025, let's say, and you appeal that and go to a hearing, and you get to a hearing in June of 2026. Yes, the termination as of March of 25 would be when you're terminated. But if Social Security makes a decision that you have medical improvement, and they make the decision, the first decision, if you want to call it that, kind of like the initial application decision, and they make that decision in 2027, it's as of the time they make the decision. They don't go back in time and say, oh, by the way, we decided that you really were disabled for a year prior to this. Again, if you appeal it, they go back. But if you don't appeal, if it's the first time around, no, it doesn't work that way. So you would not be dinged for improvement that may have happened 2 years ago when this is the first time they've made a CDR decision. Second thing is, it says you seem to make improvement. This is all very relative. It's important for your doctor to say that, you are not in, level 10 pain, you're now at level 8 pain. There's been, minimal improvement. Let's say your oxygen saturation number is no longer at 88%. Now it's 91%. It's still pretty bad. Or your pulmonary function test shows that you're still way below the mean, or way below what it should be, or your ejection fraction is not quite at listing level, but it's, instead of 25%, it's 30%. Yes, there's been some improvement, but not enough to make a difference. This is where, if you were approved based on a listing before, you can now, a CDR, you could look at the grid rules if they apply. You could look at a functional capacity argument, and you would actually make that argument that there may have been slight improvement with medication and diligence and all the things I've been doing to better myself, but it has not risen to the level where I'd be able to maintain competitive employment. And if your doctor will say that, then hopefully you should be okay. So but to answer your question, it is not overpayment as to when the note was written. It's when they make their decision. All right, Jen, super paralegal from Nebraska, is here in the house tonight. And good to see you, Jen. We talked a couple times today. And Tracy's, this is going back to what you'd written before. Yeah, it does fluctuate. I think that's, and this is actually a good time to talk about this. I'm a big believer, as you all know, in having a narrative, meaning, telling a story. And part of that story in Pricey Joy's case is her condition fluctuates. There's some times when it's better than other. I mean, for example, somebody who has gout, there may be a flare every 6 weeks. Well, I would argue that's disabling, because when you look at it over the course of a year, there are going to be too many unexcused absences. But any one day, there's no gout flare. But it happens often enough where it's a problem. So again, I think if your doctor is willing to, help construct that narrative and help you construct that narrative and talk about the frequency of the flare-ups, the frequency of the time when your condition is job preclusive, and it's often enough where it would not account for regular type of breaks, I think that would be the argument I would probably use, depending on your particular medical issue. Okay, get a case evaluation, that's in the crawl there. Okay, do attorneys have access to a client's DDDS? If you're talking about the disability adjudication, the state agency, yes, we do. Well, let me back that up. In theory, okay, once I represent somebody, I get access to the electronic folder. In some situations, that can happen pretty quickly, within a couple of weeks. Other times it may take 3 or 4 months. Jen will tell you sometimes the struggle we have getting electronic access. Once we get it, then we would have access to some of the DDS stuff. Basically, we can see what they're doing. We don't see, we only see sections E and F of the electronic folder, and that's basically the disability development. The A and B section, which is the decisions and the rationale for decisions, we are not yet able to see. That is coming. We've been told that we'll have access to the entire electronic folder other than section C, which was reserved for the judges, hopefully within a matter of a few weeks or months. So, when I look at a folder, or Jen looks at a folder, electronic folder, I can see how active or not active the adjudicator has been. I can see the records that have come in. I can look at the records. I can get my client a copy of the records. I can see what they've requested that has not been responded to. So yeah, I can see pretty much all the medical gathering, what's going on. Can an AC attorney, an appeals counsel attorney access what step you're on? I'm a little confused about that. I mean, when you say step, I know that I've talked about this before. Social Security will tell you in your My Social Security statement, you're in step 1, step 2, step 3, step 4, and that's all kind of a construct. It doesn't really mean anything. I think I remember Chad Brown, buddy of mine, was saying that step 1 means they're starting to request, or they've got the file, they haven't done anything yet. Step 2, they're starting to request information. Step 3, they've received it. Step 4, they've acted on it. But the problem is, step 3 may take 3 weeks or 6 months. Step 4 may take 2 weeks or 8 months. So the step doesn't tell you anything. It's almost like if you ever watched a football game, the last 2 minutes may take 35 minutes, whereas the first 2 minutes of the fourth quarter will take 7 minutes. So it's really not. It doesn't give you much of a yardstick as far as how long it's going to take and what that means. But if you have an attorney with electronic access, the further along you are in the process, the more information that attorney is going to have. But this step 1, step 2 that you see at your My Social Security statement, that is not part of what we see at this time. So I can't tell somebody whether they're in step 3 or step 4 as the way Social Security defines it in terms of letting people know what stage they're at, if that's what you're asking. So, because again, I think it's just doesn't mean anything, and we know it doesn't mean anything, so they don't waste our time with it, I think. Okay. Kevin, I'm almost 63. I have an undiagnosed, so idiopathic vestibular problem he's had for at least 10 years. Every year gets worse. My hours at work are diminishing. My performance is diminishing. And so, and let's see, also missed 3 to 4 days of work per month due to the condition. And blah, 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 blah. Let's see if there's anything else that he had to say there. All right. So, big picture here, you've got a vestibular disorder. And for those of you who don't know what that means, is it's typically an inner ear problem, although it can be caused by other things, where everything is just kind of dizzy. You can't stand up straight. It's hard to focus when you're looking at something. It's just turning in circles. You can't read. Obviously, it's a real problem in a work environment. And sometimes vestibular issues will be sporadic. It may happen once a week for 10 minutes, or it could be a daily kind of thing. And what Kevin seems to be saying is that it's increasing in frequency, and it's becoming worse, making it more and more difficult for him to do perform at work. So, if you've got medical evidence from a vestibular doctor, somebody who can give you a more of a firm, says it's undiagnosed. Now, again, does that mean you've not gone to the doctor, or is the doctor said they don't have a reason, therefore it's idiopathic is what they call it? I think you need to have some sort of medical assessment where, there's testing done. I know I have a friend in town who has a clinic, and she's I guess she's an occupational therapist by trade, but she does vestibular testing, and she works with people who are having vestibular issues, and there's rebalancing these little things in your ear. I don't fully understand it, but people that get vertigo, it can be treated both medically as well as with some different kinds of therapy, kind of occupational, physical type of therapy. So I think that you need to get a firm diagnosis. It's undiagnosed, meaning you're saying I'm dizzy all the time, but you really don't see a doctor. That's not going to go very far. So I think once you get some sort of a firm medical diagnosis, and then ideally an opinion from that doctor or therapist about how this would affect you in your daily functioning or at work, that would make your case a good bit stronger. That you're 63 makes life a lot easier. Again, I can see this as a grid rule argument, because if you've got a dizziness, you're not going to be able to stand and walk. So there's even though this is an internal problem, there's a physical component, an exertional component to it in terms of standing and walking. So, if you are limited to sedentary work at best, sit down work, and there's no transferable skills because of dizziness or because of whatever other reasons may be going on, then you might meet the grids at sedentary or even at light because you're 63 now. Now, the other thing you might look at doing is filing for early retirement. If you're approved for disability, they'll bump your number up to the full retirement amount, and you would get in back pay the difference between disability, which is roughly equal to full retirement, and early retirement, which might be $500, $600, $700 a month. That, as I mentioned before, can make it a little more difficult to get an attorney because, when I'm looking at a case, I get paid on past due benefits. If it's $300 a month times, 12 months, that's what, $3,600, 25% of that is not a whole lot of money. So, given the work involved in a case. So, if you do apply for early retirement, I would certainly get your My Social Security statement, ssa.gov/my account, to find out what the difference is between early retirement and full retirement, so that, if you do approach an attorney about this, again, assuming you've got a firm diagnosis, the attorney would know we're talking about $500 a month difference times however many months. Is it worth my while? Because like I said, if it's $200 a month it's probably not worth an attorney's while. So that's a practical issue, unfortunately, but it's one that you'll face because, attorneys in this area, I mean, the amount of time you're involved in the case could be 2 or 3 years. You've got staff, you've got rent, you've got all these other expenses. I can't be taking cases where my fee ends up being $300. It just doesn't work. So, just whatever that's worth, I just want you to be aware of that particular issue. But I think I would say at a minimum, get yourself a firm diagnosis, get some treatment, and maybe have somebody who'd be able to offer an opinion about the work implications of your dizziness, balance issues. Trish Wade. Hello, Trish Wade. Rob Tucker says, I am loud and clear. Okay, that is very, very good. No Sky Daddy says, good evening. Hello, No Sky. Good evening, Rodney. How are you doing? Rodney is one of our old clients and a regular here. Good to see you there. Much appreciated. And Mark says, you can hear me perfectly. Good. Good. Okay. Am I a federal lawyer? I mean, Social Security Disability is a federal agency, obviously. I'm admitted to federal court, if that's what you're asking. It is administrative, which means that we're not talking about judicial hearings unless you get to district court level. So the hearings I'm doing 3 or 4 times a week are administrative law judge hearings. The administrative law judge for Social Security is part of the executive branch, not the judicial branch. So these are hearings, but they're not judicial hearings. So, in order for me to represent clients everywhere, which I can do, it's because I'm admitted to, a state bar and a federal court. If I wanted to do federal court work, I would need to either be admitted to that federal court. Let's say, like I'm admitted to the Northern District of Georgia, provide a case in the Northern District of Alabama, I would have to be admitted there, or there's a process where you can be what they call pro hoc vice, I think as I'm pronouncing that correctly, which is basically a one-time thing. So, if let's say that somebody wanted me to represent them in a federal court in Hawaii and fly me out to Hawaii for a few weeks, which I'm not going to argue, I would need to get admitted. And what would happen there would be I would have to find an attorney in Hawaii who would vouch for my credibility and experience and things like that. It's not too hard to do. In fact, I am the pro hoc vice sponsor for several attorneys that practice in Social Security law, and I'm the person on their for any Northern District of Georgia filings. And so, before they file, they always check with me, make sure there's no conflicts, things like that, and they file it under my name. So that's a pretty common arrangement. But to that extent, am I a federal lawyer? I guess you could say I'm a federal lawyer. I practice not just state law. I practice a federal administrative law area that does at times end up in federal court. Sheila, another win. We had a hearing win from Sheila, which is great. Great. Thank you, Sheila. Much appreciate the kind words, and thank you for all that you did to help move it along. That's what we want to hear. That's great. And thanks for tuning in. Jen, yes, this is responding to Tara. We got an administrative approval in her case not too long ago. KU Thunder, good evening to you, and thanks for joining me. We have thank you. Your final review during, I think you meant reconsideration, not reconciliation. And thank you, Corlil, for the $5. I much appreciate that. My son, Jake, who does my videos, and I buy him sandwiches, he appreciates it more than I do because he gets a free sandwich out of it. And we'll use it for that purpose. But good luck. And, reconsideration, just to be honest with you, the approval percentage is not great. They do, right now, I think it's 15 to 18%, the last stats I saw. It does happen. I've had a number of them happen. But if they do deny you, don't be discouraged. Appeal it. As we talked about before, hearings are being set, 5 to 7 months. So if you are denied at recon, go to a hearing. It's not going to be that much longer. And you get in front of a judge who takes a brand new look at things. But I do hope that you are approved at recon. I have not, MDC, what's your opinion on Florida ALJ Rosanna DeLessio? I have not been in front of Judge DeLessio. Let me see if I can give you the recent stats here. And I do keep notes about all the judges I go in front of. And let's take a look here. Oops. You would think I would have this in front of me here. No. Regularly visited sites. There we go, judge approvals. There's a bunch of different sites that will do this. So let's just see. Okay, her approval rate according to this this repository is 76%, which is extremely high. Let's look at another one for you. So right there, that tells me that's a great draw. Let's take another look at this one here. Approval rates. This is a little bit older. Let's see. This one says 64%. Pardon me. So the two stats websites I'm finding, one of them says 64%, one of them says 78%. Either one of those is really good. So I think that you're in real good shape there. That's a great draw. Let me see if there's anything about this judge in the NOSCR. I don't see anything there. So there's nothing in the NOSCR listserv about her, but the two stat websites that I use both give her a very high approval rate. So I think you're in great shape. I don't know her personally, but I think that what this tells me is that she goes into hearings with the idea that I want to believe this person and I'll deny it if there's a reason not to, but otherwise, my thought is I'm going to give this person the benefit of the doubt, which is a really good place to be, good thing to have. Okay. All right. Okay, so Kevin's the one with the dizzy spells. I go to the doctors. They don't want to seem to give a name to it. I'm going to a third neurologist with not much expectations. You know what I would look at, Kevin, is look up and see if there's any kind of vestibular therapist near you, or ask the neurologist. Because, sometimes if you don't go to the right specialist, the neurologist may be looking for a particular neurological issue, and there may be something else going on. But I would look for a vestibular therapist and in your area, and just see if there's somebody there who does, occupational physical therapy for vestibular issues, and see what that person has to say. That may be more fruitful than the neurologist if you're not getting anywhere with the neurologist. I think in general, folks, when you're dealing with medical issues, you've got to really look at it. And nowadays, especially with insurance issues and with specializations, you've got to be your own advocate. You have got to be, able to say, I'm not getting answers here. I want to get answers from somebody else. I'm going to find somebody to give me the answers. And you may need to get unconventional. I've had cases, remember a couple of Lyme disease cases where people would travel, hundreds of miles to find a Lyme disease specialist that could offer different types of treatment. I had a person who, not too long ago, who had it was a COVID issue, but it was really more from the vaccines. And he found a specialist in Colorado, went halfway across the country to talk to this person about long COVID and effective vaccines. And he's, got some medications and treatment. I'm not saying he's fully recovered, but I think he's doing better. So, there are people out there who have unconventional approaches to medicine, not just about surgery or giving you standard kind of medications, but more creative more creative approaches, and that may be what you want to do. So again, see what the neurologist says, but I would really look for a vestibular person, a vestibular therapist, consultant, to see whether that might give you a little more relief. Because at the end of the day, you want to get better. That would be even better than pursuing disability. Okay. I was diagnosed as Stargler with schizoaffective disorder, bipolar, can't keep a job. I just started treatment. I'm going to apply for SSD on a neurological disease. As a recent diagnosis hurt? Um, yeah, it's kind of hard to say. I don't think it hurts. I mean, I think that again, the big picture here is you may have been struggling with a problem that didn't ever get diagnosed, but now looking back on it, your doctor realizes you have had schizoaffective disorder or bipolar for many, many years. It just was recently diagnosed. Um, some judges, as I was talking about earlier, recognize that these conditions don't just spontaneously arise on a Wednesday morning. They've been there for a while. Obviously, the effect and the symptoms. If you look back and realize, okay, these symptoms are very consistent with this diagnosis. I've had this for a long time. You could argue, try to go back earlier than that, than before you got diagnosed and treated. And again, the worst would be if a judge is inclined to approve you, wants to change the onset date to your diagnosis date, then that's what they're going to do. But I think you can certainly ask a doctor, your psychiatrist, to offer an opinion about when this condition seemed to have been, becoming work preclusive. And even if the doctor's willing to basically say, well, based on what my patient has told me and the other records I'm saying, this looks like this was at a pretty significant level 2 years ago and you weren't working then you could possibly go back a year or two, which you realize that when you're applying today, you can only get paid a year back. So, beyond 18 months, because you factor in the 5-month waiting period, it doesn't really matter when your onset is, assuming there's no day less insured problem. So if you can go back a couple of years, that'll max out your money. But again, it's going to depend on what the doctor says and how the judge might be inclined to assume that your condition was work preclusive without a firm diagnosis. Okay, and Carla says you said it was reconsideration. That's correct. Okay. If you're approved and you move outside the country, like Mexico, can you continue treatment doctors outside the U.S.? You can and you should. There is a pamphlet that Social Security publishes, and you can look it up, saying collecting SSDI benefits outside the U.S. And the countries where it's not a problem and the countries where it is a problem. Obviously, if you move to Iran or North Korea or Venezuela, it's going to be a problem. But other than those countries, it won't be a problem. But you need to look up and see. And as far as the medical record, I've had cases where I had a case was approved. In fact, the person who we got approved, he and his wife have been on the live stream in the last few weeks. But some of the records were from Mexico, and you get them translated, and it's not a problem. So, you can continue treatment with doctors there. Many times it's a lot cheaper, and that's why people do it. They call it medical tourism, although you could certainly live there too. But that's what I would do. Just keep the treatment up, is what I'm saying. You think I've shed a pound or two? Maybe. I mean, I've been playing a lot of tennis. I mean, I realize, if you don't know this already, losing weight is not about exercise. It's about what you put into your mouth. I've been eating a lot of salads, trying to drop a few pounds, playing a lot of tennis. So probably have dropped a few pounds, but need to drop a few more, but it's always difficult. But the summertime is good because I'm out walking the dog, playing a lot of tennis. I was actually in a round robin tournament this weekend, basically just at the facility I play out of. There's like 20, the director got 24 of us who, play on teams out of this facility, and they did a round robin, and we were all seeded based on ability. And there are some of the guys that were, a good bit younger than me that are, a lot quicker and very, very skilled. Then you had a few people that were older. They're guys in their 70s and even 80s. And so, I don't know where I was seated, but what they would do is they would put, people, they would say the guys that were, the studs, the, number one player, number one seed, they might put him with the 81-year-old guy. And then, they would keep reseeding it and so forth. So I ended up coming in third. And it should have come in second, except because I had one match with the number one seed. It was on my team, and we were playing a guy who was like, ancient. And for some reason, my partner decided to not, not put the ball away, kept, hey, get back to this guy. We ended up losing it was we played 4 games and we lost one of the games. So instead of being 4-0, we were 3-1. So I ended up in 3rd place by 1 game. So, I should have been in 2nd place because my partner was trying to be a nice guy. And, so I don't get the little piece of plastic trophy, which is probably just as well. But so for my purposes, I was 3rd, but it should have been 2nd. But anyway, it was fun. And, but yeah, I'm playing a lot of tennis, and that was 3 hours plus of running around and, again, walking and so forth. And yeah, it's always good to get some exercise and get out there. So, and I think I played like 5 or 6 days. I didn't play today, but I played like 5 or 6 days in a row. So I'm running around. I just need to eat a lot of salad, but I just need to probably cut back on the pretzels and the popcorn and the carbs, which I like. And actually, it just as another aside, which nobody really cares about, I'll tell you anyway, because it's my live stream. We went to dinner, my wife and my son and daughter and son-in-law and grandchild went to dinner at a pizza restaurant on, I think it was Saturday or Sunday maybe. And so I'm ordered a salad and a pizza, and I'm eating my salad, and I look down, there's a ladybug in there crawling around. So I called the waitress over. I wasn't making a scene. I just want you to know I can't really eat this. I've eaten 3/4 of it. You take it away, but there's a bug in here. You might want to make sure that you wash your lettuce a little bit better. So the manager comes out, and he was very nice. And I just said, look, it's no big deal. I'll come back. He goes, I just want to make it right. So he gives me these 2 huge pieces of chocolate mousse cake. Like, this is all that I need. So I've been eating that all week, 3 or 4 bites a day of that. So, so it's always a struggle. I got a sweet tooth, so it's always a struggle. Okay. So that's, more about my tennis round robin and my pizza adventures than I probably ever wanted to know. All right. Hello, Vince. How are you doing? Good to see you. I hope you are warm where you are. I know Vince and I always go back and forth because I think you're in Michigan or someplace where it's cold normally, but it's warm now. So, and he's one of my clients, so we're going to hopefully get him approved soon. Jeff Brown says, good evening. Hello, Jeff. Can you receive a CDR if you're living in another country? Yes. Is it possible to have to come back to the States? You wouldn't have to come back to the States. You can probably do your hearing if you go that route by virtually. I'm not aware that you would have to come back. I think it's just a lot of this is done by paper, in terms of the forms you fill out, and then the hearing could be done virtually. So I don't think you have to come back. Rodney says, you think CDRs will be imminent for claimants today? No, I don't. I think that they don't have enough people as it is. They're not going to waste their limited human resources for going after people who are close to retirement age. They're going after people in their 30s and 40s, not people in their 60s. Okay. So somebody in my staff says, leave me a review. Please leave me a review. I'll put that crawl up there as well. And we always appreciate reviews. They are people use them nowadays to find lawyers, and it's been real helpful to me. Got a lot of reviews, a lot of good ones, and it really is much, much appreciated. What are those purple crowns? Purple crowns. I'm not sure what you're talking about. Are you talking about with me? Oh, well, no, I don't know. I don't know. Pricey Joe, if you can tell me what you're talking about when you say purple crowns, unless I have a blur in this. Maybe you're seeing just around my head because I got a blur. And basically this is my home office. And it's just, I've got my video camera there, which is where I do my videos. And I've got this blue thing here is that's a trash can where I've got documents I need to shred. So I've got to shred them, and I've got a shredder here. I just haven't gotten around to that. And this thing here is a movie light. This white thing here is a movie light or a video light. So I'm not sure what you're looking at, but tell me what you're looking at, and I will try to answer it for you. Jackie, hello, Jackie. I'm doing well. Hope you are doing well as well. Christina, one of our regulars. Hello, from Christina from California. Kelly from South Carolina. Hello, Kelly. How are you doing? And No Sky says to Christina, hello, Christina. Hello, Jen. Okay. All right. The grid rules, I think I talked about the grid rules website for the person with vestibular issues. That's the link is thegridrules.net. KU Thunder, you get 3 wishes. Maybe that was what you're asking about. I don't know. I'm not sure what the 3 wishes. I'm not sure. Right. Okay. So Terry, and okay, well, one of my former clients, we'll leave it at that, wants to know if you win your claim under the grid rules, we still get a CDR. No, I mean, I can't ever say you won't get one. It's very unlikely at 57. And winning under the grid rules, winning under the listing, it doesn't really matter. I mean, you won, we won. That's the most important thing. But I think that anybody over 55 is just not a target because they just don't have the staff and the odds of somebody having a miraculous recovery after 55, it just starts to go down. When you're 35, you're healthier, younger, and you're more likely to probably have a recovery. Number two is you're going to be pulling from the Social Security system for another 30 years. So they're looking for a reason to cut you off. Medical improvement again being more likely. When you're 55, you're getting close to retirement age. Medical improvement not that likely. They're not going to spend their staff people on people over 55 unless they see a lot of earnings come through. If I was 50 at approval, safe to assume it really depends, Pricey Joy, on what the basis of your claim was. The grids only apply if you have what are called exertional limitations, meaning it's got to be physical, limiting you to sedentary light work. If it's mental health, if it's pain there's no exertional limitations, the grids would not apply. I will also tell you that when I look at decisions, for whatever reason, judges tend to write decisions in a format where they'll say, my analysis of this person's residual functional capacity is that no work would be allowed or no work would be possible because of the person's unreliability. The vocational expert testified that, a person who is off task 15% of the day or more would not be able to maintain employment. A person who missed 2 or 3 days of work a month not be able to maintain. Even in the event that the residual, my capacity evaluation is off, the grid rules apply. So usually their judges are using the grid rules as kind of a secondary, like a backup reason. Every once in a while, it'll be the primary reason. But it wouldn't surprise me if your decision by either a state agency, adjudicator, or a judge does not reference the grid rules as the main reason. That is not a surprise. Now, why they would be reluctant to use the grid rules as opposed to functional capacity, I can't tell you. Maybe we'll ask a judge sometime, but I wouldn't assume that. But again, the most important thing is you're approved. Has anyone had an issue with you get an award, they failed to add the COLAs, the cost of living? Yeah, I have not seen that, but you did the right thing. Contact your senator. Pricey Joyce says, I just turned 54. Again, 55, 54, you're not, anybody over 50, let's just put it that way, you're not their prime target. If you're 30, yeah, you got more of a likelihood. I think they also code these things where when you're approved, they look at the likelihood of improvement and they give it a code. And depending on what the medical condition was that produced a favorable decision, that might also tell you whether you're likely. But I just think that anybody in their 50s, I just don't see it very much. It's just they don't have the people. They don't have the people. They have fewer people now they've had years. Do the paid sick leave offer time off hours for monthly earnings for TWP? I think that for trial work period, I know that, in fact, I just did a seminar about trial work periods earlier this week for a continuing legal education program. I know that the medical devices and other things that are used to allow you to work are not deducted from the trial work period. I think that paid sick leave, trial work period is going to look at the earnings. So if you are, and what is it, $1,160 or something for 2025. So if you are getting paid more than a trial work period, service period, that'll use up one of your months. I don't know that it makes a difference whether it's sick time or regular earnings. I don't want to say absolutely. That's an interesting question. So you're saying if you got sick time, but you were getting paid your salary, could you argue that they should not count that towards your trial work period? Um, I don't know for certain. My hunch would be that it's not going to help you. That they're just going to look at those earnings regardless of whether sick time or whether they're employment earnings. But I don't know for certain. Let's just see if I can find the answer for that real quick. So will payments for sick time count for, let's see if I can get you an answer here. So it's $1,110. Okay. So what I'm seeing here is that sick pay is counted as earnings, so it's paid by the employer and attributable to work activity. So without doing further research, that's what Dr. Google says, which kind of makes sense given that they don't give you credit for assistive devices or other things that allow you to work, whereas they do give you do reduce your SGA for that. So I'm going to say a qualified that they do not deduct sick time or anything like that. They just look at the actual earnings for trial work period. That's a very interesting point. I was actually thinking about doing a sort of a little mini seminar I'll put on the YouTube channel about trial work period, since I just studied it for this other seminar, and that would be a question I'll get a definitive answer to, and I'll put that in the presentation. I'm hoping to have time to do that soon, but my guess would be that that they do not deduct it. Okay. Not in the mood for joking. Not sure what that means, but okay. Let's just say $7.95. That's the Form 2. Not coming true. Okay. All right. This is if you need a statement, whereas a statement by claimant or another person would be in Form 795. Not coming true. So again, I think you were asking me, Pricey Joy, about whether a 54-year-old would be in a more likely to get a CDR than a 55-year-old. I think a 54-year-old might be slightly more likely to get one, but still, it's a pretty, let's say that the odds for a 55-year-old are 5% you may get one. Maybe it's 10% for a 54-year-old, but it's still 90% that you won't. Cornell Bailey. Okay, when I went to start my application, I asked the person helping about the grid rules. She told me to know anything about that. Knew I was in trouble at that point. I was working. All right, so I would say this: if you're applying for benefits and you've got somebody who's theoretically a professional helping you, and they've never heard of the grid rules, that's not a great sign, because the grid rules are one of the 3 theories of disabilities, and so if you don't know about them, you're really proceeding with one hand tied behind your back, because it's a great argument to make. And again, it just gives more reasons to get somebody approval, more reasons for Social Security to approve you. Heather W. Had my hearing. I knew my past substance abuse was bad. Medical records that shows home for help. 2 years clean. ALJ didn't ask about it. I'm 61. Rep says it was not material. I would agree with your rep. If you've been clean and there's no reference to any use of it, and the ALJ didn't ask about it, I don't think it's a factor. The ALJ might reference the decision that he or she made the conclusion that your substance abuse was not a material contributing factor. Again, no evidence that it was. It's non-issue. I would agree with your rep. I think if a judge was to deny your case based on substance abuse when there have been no questions asked about it and the record suggests there's nothing ongoing, that's appealable. But I don't think it's going to be an issue for you. Okay, so Sheila is one of our clients. Thank you for that. Okay. Okay. All right. Donnie Doomsday. That is let me just put my other banner up here. Donnie Doomsday. That is a pretty dark handle. Spinal stenosis, nerve root impingement, age 35, SSI, second time trying, MRI and x-rays, trying to avoid surgery. I would tell you this, Donnie. The big issue is your age. You've got significant medical issues. You're 55. I think you got a really, really strong case. 35, some judges are going to see 35 and they're just going to say, you're too young. Other judges or adjudicators are going to say, let's look at the underlying medical problem. It's pretty serious. That's obviously pretty serious. You're going to have to prove you can't do anything at all. So I think you're going to need, obviously, strong medical evidence. You've got an MRI. I would get non-medical evidence, statements from former coworkers. I guess if it's SSI, you may not have any, maybe third parties who've observed you that can talk about the functional issues, really think about the issues you have just with activities of daily living, grocery shopping, cleaning, bathing, dressing, things like that. And you're going to have to just show that you're just so impaired that even a simple sit-down job would not be possible. And again, being 35, you really have to go, it's going to have to be really, really compelling because they just don't want to approve people in their 30s. Just as unfortunately as simple as that. Okay, so this is about the person who asked about this, how quickly we're seeing hearings. She's 5 to 6 months. That's about what I said. I think I said 5 to 7 months. We've got to get 75-day notice. I think I said 60 or 75 days. We can waive that, but that's going to be right there, 2.5 months. And then, by the time they schedule it, I mean, let me tell you this, when I have there's a utility that we use to let Social Security know about my availability for hearings. So I have to do them 6 months in advance. So that means that, they're scheduling hearings, 5 and 6 months out. And so, that's kind of where that number came from as well. But that's pretty typical, 6-7 months out is pretty typical before we get a hearing. Okay. Do I have an experience with quick disability determinations? What to submit immediately? Detailed medical records. My understanding is that's something that is more of an internal thing. What that is basically where Social Security has an internal policy where certain cases are flagged as being eligible for a quick disability determination because it's so obvious. I mean, a person with ALS, a person with, stage 4 cancer, really serious types of things. And they're supposed to spot it. Now, if I have a case where I think that should be, I will tell you, every once in a while somebody calls me and, with a case where it's a terminal cancer case, they're going to get approved right away. Yeah, I'm not going to get paid for it. That's fine. It's just something you do because you want to, it's the right thing to do. I will put on the application, please screen this for quick disability determination. I think that if you think this is a QDD case, I would get them as much as you can, as quickly as you can. I think any condition that is one that is certainly in the compassionate allowance list, it is something very, very serious, life limiting, doesn't have to be, you're going to die in a year, but it just means it's something that is non-treatable or minimally treatable, not curable, causes severe functional issues. I think those are the ones that they're going to be looking at where there's objective testing. You're not going to see a QDD for the most part in mental health cases. It's going to be typically something where there's an objective test. Okay. All right. Cornell was the one who said that the person did not know. I think you were the one who said that you're talking about somebody who did not know about the grid rules. I was working at the time, a doctor put me out, and I've been back to work since April. I'm also 100% VA. Can I proceed with SSA? Yeah. I mean, you can certainly, again, when you're saying SSA is not responding back, do you mean For retirement, I'm not sure if I understand what that means, but if you are 100% VA, that'll get you in the front of the line. That'll speed things up. There's really no reason, if you have a disabling condition that's going to keep you out for a year, go ahead and start the disability process. No reason not to. Okay. All right. So I think we talked to Donnie before. Okay. Okay. I would agree I would agree with that. You're not necessarily going to be denied because of substance abuse. All right. Justin D. Have a video hearing next Wednesday. I can only wear a scarf on my head. Can't comb my hair. Neuropathy and fatigue will do your frowned upon. I would let the judge know. I mean, if you've got an attorney, that would be part of my pre-hearing brief. That my client, cannot, his hands would not allow him to comb his hair. Of course, not wearing a scarf, a judge would be able to see, that your hair is not combed. I think, you can certainly, in a video hearing, that's the advantage of a video hearing. Judge can see you. So, again, if you've got an attorney, you can talk to your attorney about whether it makes sense to wear the scarf or not. But certainly, whether you do or don't, you can explain to the judge either verbally or in writing beforehand that I'm either going to be wearing a scarf because I can't reach up to comb my hair, or my hair is going to look like a complete mess because I am, unable to comb it. Okay, John asked about SSD with no COLAs added for back pay. And I think you're the one who said I contacted my senator. Yeah, my response was that that's exactly the right thing to do. If they're doing it incorrectly, then your senator is the one to ask the question. They will get it. He or she will get an answer. John, and hope that answers the question. All right. Okay, so I think Heather was the person asking about whether substance abuse that was not addressed, not in the record, is that going to be a problem? And again, my opinion would be no. I know that Heather and Pricey Joy have been having a discussion, but I think that my opinion would be if it's not brought up, it's probably not going to be a factor. And given it's not relevant because you're clean and sober, I don't think it's relevant at all. All right, Rob Tucker says, I get denied the set of limitations. Is that a good thing or bad thing? This is a classic, it depends. Now, if you are, and I'll give you an example. Let's say, so first of all, I think if you have limitations, that says that maybe down the road, that would be the starting point for a new application. So that in that sense, it's positive. I had a case not very long ago, last week, where my client went to a hearing, was denied, and at the time, the judge used the 15, back then there was a 15-year look back on jobs, now it's 5 years, and my client was found capable of doing sedentary work. The decision said up until this point, light work, and then after something happened medically, he's limited to a sedentary kind of work. And we filed a new application. And now my client's at an age where sedentary work between 50 and 54 would grid him out because he's now 50 years old, 50 plus years old, limited to sedentary work. There is no past work because, again, with the 5 year look back, there's no past work. 15 years there was, but 5 years not. So I got a situation where, no past relevant work, 50 to 55, limited to sedentary by prior decision. And there's actually a ruling by Social Security in the Fourth Circuit, which is Virginia, where this case was being held, that the judge is bound by that prior determination, absent really unusual circumstances. I put that in my brief, and the judge, I don't think had heard about this or knew about this. I'll look into it. I'm like, well, I'm going to appeal. I'm thinking to myself, I'm going to appeal the hell out of you if you don't, because this case should be approved. So I'm thinking it'll be approved. But that's an example of where prior limitations, even if you're denied, can help. This is also something where if you're in the 60-day time for appeal, talk to an appellate lawyer maybe the limitations the judge found were not severe enough. And maybe the appeals council or district court would say, well, wait a minute, this level of limitation the judge found is too light, should be more, because this type of impairment should create more limitations. So it's always good when a judge finds there's something as opposed to there's nothing. And again, they're usually going to find something, but how much it was. But it's just going to depend on a lot of factors and what you plan to do going forward. Hey, Sharon. Okay. They don't know in the background. I know I've got somebody calling on that. Sharon's a client of ours. We won on the record decision prior to the hearing, the day before the hearing. I got paid, which means you should have gotten paid. And I've got someone in my office calling on that. So I will have Jen, and Jen, I assume you're still listening. That's something that Stephanie needs to be calling about, because we need to get an answer for Sharon. That's ridiculous. And we may need to, contact the senator's office as well, because that's something's not right, what I'm saying. Joey Joe. Hello, Joey Joe. Okay. This guy works with me. As you probably can surmise from this, put your questions in the chat. Okay, 53-year-old Joey Joe with 10th grade education, obese, diabetes, COPD, asthma, anxiety, depression. The 10th grade education helps because it means there's probably not a lot of transferable skills. The question is, do you have any support for an argument that you're limited to sedentary work? You can't stand for more than 2 hours. A lot of these things, the diabetes might, if you have neuropathy in your feet, same with the COPD and asthma, anxiety and depression aren't going to limit you exertionally, but they would certainly, make transferability of skills a problem. Sleep apnea, again, same thing, focus and concentration. So I think really the question is, do you have a doctor who will put it all together, who will say that you would be limited to no more than a sedentary RFC, residual functional capacity? If so, then the grid rules most likely would apply for you. Okay. And migraines, again, hip replacement. So again, hip replacement is going to affect you exertionally. So, all these things suggest that you might very well be limited to a sedentary work capacity at a maximum. But again, that's what I think. You need to have your doctor say that. Okay. TTAM tubu. Okay. I originally qualified for SSDI for 4-stage colon cancer. I survived, thank goodness. I've been cancer-free for 5 years. I diagnosed with Parkinson's disease about 4 years ago. I did not inform SSDI of the change and have remained on SSDI. You need to inform them. I think that I would let them know about I would say this. I mean, they, I believe, have availability to request your medical records using the Form 827. If they don't, when they send you a short form, it asks the question for a CDR, has any doctor said that you've improved? Well, they haven't sent you a short form. My inclination would be you don't volunteer anything to them if they don't ask you. It's very possible this was coded where they did not expect improvement, and maybe you're thank goodness, one of the few that actually have been cancer-free after stage 4 colon cancer, but now you've got something else which is most likely also debilitating and probably work preclusive. So my thought is, if they ask you, notify them. If they don't ask you, wait till they ask you. I just don't. I've always been a believer that the less said, the better. If they ask you something, you're not misleading them. Nobody has said that you are able to go back to work, and now you've got this new thing going on. And so, what you don't want to have happen is you advise them sort of proactively that your cancer is no longer an issue, although again, are there residual effects in terms of bathroom issues, pain, things like that, or medications, whatever. But then now you have to start the whole thing all over again to try to prove that the Parkinson's is debilitating. My thought is that wait for them to call you, don't call them. Okay. My wife has stage 4 metastatic breast cancer. I'm sorry. Spread to her spine, hip. Is there any reason should be declined? No. I mean, she's got a compassionate allowance. Look that up if you're not sure what that is. The compassionate allowance is where they have conditions that are unfortunately, terminal or really, really serious. They're all, a subset of the listing. So when you apply, reference the compassionate allowance, reference the listing, ask for a QDD, a quick disability determination. You should be approved. She should be approved within a couple of months. I'm very sorry to hear that, but that's my thought. You shouldn't, I think if you give them all the information, they should not turn it down. Is it possible? I guess it's possible, but probably pretty unlikely. Okay, John Bowl. Hi, John Bowl in South Carolina. 19-year-old has ADD, Asperger's, OCD, depression, anxiety, pathological demand avoidance, agoraphobia, and a few more. He's never been medicated. What evaluation to help him get? Yeah, I think it will. I think that, medication is one indicia of severe or of severity of a mental health problem. But certainly a comprehensive psych evaluation might give you enough information to show Social Security how serious and work preclusive his symptoms are. If the symptoms are or the conditions are ones that are typically treated with medication, then the question you'll have to answer is, why no medication? Now, maybe he had a bad reaction to them. Maybe he's got allergies to them. Maybe, who knows? So I think that question will have to be addressed because the Social Security's hive mind, as it were, is let's say you get a very thorough evaluation about all these conditions and how they impact him on a day-to-day basis. The question Social Security is going to ask, well, if he was taking the medications that were recommended, would he have more functionality? And again, this gets back to, can you refuse medications? Yes, if you have a really good reason for them. Is refusing a psychotropic medication the same as refusing surgery? No, but there's also a lot of side effects to these medications, and some people have violent reaction to certain medications. So I think I would want to know why and be able to answer the question as to why medications have never been used. They're either not prescribed, they're not appropriate for the condition, or he's had a really bad reaction in the past, or you're concerned about a really bad reaction. I think that would need to be addressed, but a thorough assessment would be very, very helpful. Yes, absolutely. Munir Jafar. Hello, Munir. Thank you. My health exam was done 2 weeks ago. I'm 63 years old, bad knee. On 2 years August, crucial pain. What do you think decision will be? Well, again, if you had bad knee surgery, you're 63, and you can't stand for you can't stand 6 hours, then right there, I see a grid rule argument. At 60, they have to prove that there's what they call minimum vocational adjustment from past work. So I think that's going to make it easier to meet the grids. That profile, again, assuming that the medical record shows significant problems with the knee, the function of the knee, and pain associated with your knee problem. I think that it looks like a grid rule argument. I think it's a pretty strong argument. I think you've got a pretty strong argument, assuming that the medical lines up with what you're saying. So I do think you should get approved. Whether it'll be approved at the initial recon or at a hearing, I can't say. But I think this is one that, I'm seeing the Social Security approve at the administrative level, the initial and recon. Let's see. Okay. And Pricey Jordan, Heather, I'm not ignoring you. I see there's a kind of ongoing conversation, which is really kind of between the two of you. All right, essay. Total pain clinic, I was at a 7. The pain would go to 8 or 9 upon exertion. I was always at a 4 or 5 would go up the exertion. Short in 2 weeks. Highest was 9 and average was 5. That's not what I said. And again, this is where you might go back to, I think Jen put this in the notes here, if I can track it down, the link to the form 795. Okay, here we go. So this is the link. Grab that form. It's just a blank form. You can fill it out online, where you could basically say, this is what I told the doctor, not what is in the notes. And you can ask the doctor to change it, or you can just put that in your record so that, it's clear to everybody you didn't say anything about, an average, and this is just kind of a made up kind of thing. Is it going to make a difference? I don't know. But having that in the record at least will give you, if a judge was to rely on the record that talked about, I'm just going to go back over here to, the highest was 9, the average is 5, and the judge decides, well, that does not reflect a severe level of pain. You've got your statement in the record saying that's not what I told the judge. Okay, and procedure knows about the vestibular. Yeah, it can be very, very serious. I agree. Right, they rebalance the crystals. That's exactly right. Yeah, I think that, and what Pricey Joy is saying is that, if you get the crystals rebalanced in your ears, and these are, I don't understand it all, but it sounds like really new age crystals, but it actually is it does work. And again, a friend of mine, Peggy, here in town, is a vestibular therapist, and that's what she does. And I know people we've sent to her, friends and so forth, and they come out and they're like much, much better. So it's not an immediate thing, but it's something that can be done. Okay, Alicia is one of my clients. As my hearing date approaches, does it make sense to include your test results coming from a brand new medical issue? Would it just scale down disability of the words for all? If it's a brand new issue, I still think I'd probably want to include it because it's just diagnosed. It's not like you had it before and didn't tell anybody about it. So let Jen know, and we'll get. We want to have a complete record. Is the bottom line. I want a complete record. As I said, I think we got a pretty good judge. I want to get a complete record. So if it's new, we'll talk about it, whether it muddies the water. But my guess would be we need to just include it in there to make sure the record is complete. Okay. Okay, so Heather had a non-attorney rep, and this is the one I think was about the substance abuse issue. So again, I don't think that that's going to be an issue for you, as we talked about. Jen's talking to Sharon, our client. Jen, the issue, and you and I talked about this offline. The fact is, I got paid. And normally when I'm getting paid, the clients should be getting paid around the same time, which says to me there's some sort of a holdup. I don't know what it could be. I know, as you recall, we had a client who was a green card holder. And that particular client, it was a holdup because they needed some information there. And, maybe that's an issue here. Maybe there's SSI. I don't know. You and I need to talk about it because we're going to make sure that Sharon's taken care of. Okay. Okay, all these people with non-attorney reps, what's the deal here? No, I'm just kidding. I mean, there's some non-attorney reps who do a pretty good job. Some of them do, some of them don't. I guess that's true about attorneys as well. But okay, Yanni, can you apply? You can. This is, and Dan says yes, you can. Here's my take on that. When you apply for unemployment, you are basically saying, I'm ready, willing, and able to work, which is what I would translate. You're ready, willing, and able to try to work if a job was made available to you. That is not a medical determination. You're not a doctor. So you can't say for certain you can or you cannot work. Because what if you went to a job and you couldn't do it? So I don't think that there's an inconsistency there between applying for unemployment. About 10 plus years ago, judges were asking that. And there were a few judges back in those days who would they would amend the onset date until after unemployment ran out. They thought it was inconsistent. I've not seen that in 15 years. 10, 15 years. So the answer is yes, you can apply when you're on unemployment. Most judges realize you're trying to survive. And again, that you're applying for unemployment is you're saying I'm willing to try to work. There's nothing wrong with saying you're willing to try to work when you're applying for Social Security as well. And you got failed work attempts. So I don't think that's a problem at all. Okay, Russell says, I might come back from, what this is about for those of you who tuned in late. Somebody asked me about, I can't remember how it came up, but it was something to the effect of that, if I had, am I a federal lawyer? And I just said I can represent clients in any jurisdiction because it's federal. And been admitted to the federal district court here in Georgia. I said if somebody wanted to have me represent them in Hawaii, I would be happy to do so as long as they paid for my flight and put me up for a couple of weeks. So Russell's comment is I may come back wearing a grass skirt. Maybe. I don't know that I would, but I certainly wouldn't mind the trip to. I've actually been to Hawaii once when I was. Let's say I've only been once. I've been twice. I was when I was very, very young. My parents, I was an only child, so it was no place to leave me, and I didn't have any real relatives for them to leave me with, so they would take me. And my dad was a magazine publisher, trade magazine publisher, and they had a convention in Hawaii. So when I was like 9 years old, I went to Hawaii, and I remember a little bit about it, but it was it was kind of cool. And we were in Oahu, and it was like kind of Miami Beach or whatever. And Oahu was sort of very commercialized even at that time, and it was kind of cool. And then when I got married. My wife and I, was 1988, we went to Hawaii as part of our honeymoon and went to a couple of different islands. It's beautiful, very expensive because everything has to be basically imported. But it's really pretty. I didn't play golf with it. I still don't play golf very much. If you're a golfer, it's just, beautiful. The golf courses, you see the volcanic islands, in the background and so forth. It's beautiful. It's nice beaches. Of course, there are nice beaches in Florida and, California and other places as well. We took the one thing I remember about it, the honeymoon was my wife was actually sick. She got food poisoning. And she was nice enough to say, just go ahead. So we had booked a helicopter trip to go into a volcano. And so we get in this helicopter, and at the time, all these guys were like, had been military pilots. So they were a little crazy, and they were, zooming around. So we're in this helicopter, I'm strapped in, and all of a sudden to my left, I'm in the right passenger seat. There's like two rows, and I'm in the back, the right. All of a sudden on the left, the door flies off. So we're in the helicopter flying over a volcano, and the door to the helicopter flies off. And fortunately, everybody was buckled in, nobody flew out, but it was it was quite the experience. And so he has to land the helicopter. He found a place to land it, and I guess by law, whatever, and they had to bring another helicopter in to pick us up and complete the tour. But it was quite the experience. So that was my Hawaii story. But it's a beautiful place, long way away from Atlanta, certainly, and very, very expensive. But if I have a chance to go, I'll go. And if somebody wants to pay for it, I will go even more. Rob got denied. They said limitations. Okay, I think if you're saying I got denied at an initial recon, they found some limitations, but not disabling limitations. Yeah, I would just say, again, without knowing the facts, you would certainly want to appeal that because a state agency many times finds limitations, but not disabling limitations, whereas a judge might look at it differently. Madeline, hello. Madeline's our call screener. Good to see you, Madeline. And I hope all is well with you in Oklahoma. Are we getting the stimulus in? I don't know. I have no idea. No idea. Heather is the one who had the substance abuse question. Don't be a nervous wreck. Don't be a nervous wreck. I think that's not going to be a problem for you at all. Kevin says you've been through it all. Again, it's got to be really frustrating to have a condition like a vestibular problem and not have any kind of solution offered to you. I can't imagine what that's like. Dan Deniganis. Okay, well, good for you. And again, people do get it sometimes. I mean, and I, I'll tell you that currently, I think Social Security, if there's cases that are listing level cases, they want to get them approved quickly. And so, we see, I wouldn't say that the number of early approvals has gone up dramatically, but, they're approving cases. They seem to be a little more receptive to it. I don't think they want this backlog they have to deal with. Jennifer, hello, Jennifer, waiting for a hearing date. Have cervical surgery Tuesday near the surgery. How can? Well, again, I think that one question would be, at what point after surgery will the doctors know whether it's been successful? And that might be a question the judge would ask. And I've seen judges in the past when somebody has surgery. I don't think we have a hearing date yet, but I think that. I've seen judges leave the case open for 6 months to see whether or not the surgery was successful. So I think that anytime you're a surgical candidate, that's indicia of severity. And after the surgery, hopefully there'll be good results. And I'd rather go with a closed period and see you back at work or see you back feeling much better. But we won't know, you won't know probably for a while. And whether that's 3 weeks or 6 weeks or 4 months, I don't know. We just, that's one of the things you got to just see. But I would just kind of take that day by day after the surgery. And if you need another one after that, again, that's indicia of severity. But if you have these surgeries all before your hearing, I think judges might want to know what the result was, and they could leave it open or I've seen judges put people on a 1-year review to see, they approve them and put them on a 1-year review to see if the surgeries help restore their function. Okay, Christina is, I appreciate that as always, asking people to leave me a 5-star review. And if you find my information helpful, that would be great. I would really, really appreciate that very much. I'll put the crawl down here, how to do that. And those reviews are good. Melissa from Facebook, neck and back fusion, stenosis with calcification, 57, worked for 2 years, currently in reconsideration. Struggle, sitting, standing, medical doctor. Okay. If x-rays, so in the consultative, they probably ordered x-rays because they don't want to pay for an MRI. I mean, but you got a good case. I mean, this profile is a winning case. I would take this case in a heartbeat. Good case. I think that you got significant objective evidence there. Your condition, your symptoms, struggling. So you need to quantify that about how long you can sit, stand, or walk. 10 minutes, 15 minutes. I think I see a grid rule argument here, functional capacity argument. There's depression as well. I think it's a strong case. I really do. I think you're probably in pretty good shape here. And hopefully they approve you at recon, but certainly I think at a hearing, a judge would approve you based on that. I heard his SSA, very good question. There's using AI. What are your thoughts about AI? And I'm using AI. I'll tell you, I use it to come up with topics for videos. I've used it to create PowerPoints for a continuing seminar. I've used it to put together arguments. You got to be real careful about personal information. If it's a closed system, meaning that it's not being used for training. In fact, I'm taking I just joined a mastermind group about this very topic, about how to keep everything private. I think that Social Security will certainly use it. I don't think there's any question that they're going to use it to determine which cases are much more likely to be approved. And so they can, approve them. On the other hand, Social Security has also been known to, deny cases so that it takes more time, so the money doesn't get paid out as soon. But I think it is, and I will tell you, having used it for a number of different purposes, again, putting together CEs, doing case summaries, things like that. It is a true game changer. I mean, AI is a true game changer. It is unbelievable. I mean, it's like having a clone of you, a robotic clone of you sitting right next to you, and doing analysis, writing things up, preparing things that you could do. I'm talking about, or I could do, that might take me 4 or 5 hours. It'll do it in 30 seconds. And it's not going to do it exactly the way I do it. And I would never turn something in directly out of an AI engine, but it's a starting point. So instead of working off a blank piece of paper, I'm working off something that has already been, kind of partially digested. And again, the example I gave is taught a seminar on Monday about the trial work period. And so what I did was I used an AI engine called Notebook LM, which is the Google product, a Google product, and I've got the paid version, and it's closed, which basically means that you give it information, you upload documents to it. It doesn't keep them. In fact, it deletes them, and nothing is saved. It's not used to train other things. It only uses what you've given it. And so I uploaded a bunch of prior seminars, resources about trial work periods, and then I, said, create for me a 45-slide PowerPoint about trial work periods, and it did. And I would say about 90% of it was usable. I mean, I had to make a couple of changes. There were a couple of things in there that I thought were not clear, but it was very, very usable. Then I had to put the materials together, because when you do a seminar, you have to give written materials. And so I gave it the parameters of the materials, the topics I wanted to cover, write me a, 10-page, summary of trial work period, and organize it the way, in outline format, the way it needed to be done for the seminar. It does it. And like I said, it was not 100%. It was pretty close, but it saved me immense amount of time. So I think that, it is a true game changer. It's still evolving very, very quickly. Again, I'm in this mastermind group, and we're talking about Chat GPT. And again, there's a paid version, there's a free version, and you have to set it up where it doesn't save things and all that. And you still have to be careful about that. I've not really used Chat GPT because I don't think it's as private as I would like. And I know Microsoft has one where you can do it literally local. So it's completely contained. But yeah, it is a game changer. So Social Security will be using it, no question about it. And I think it is a very useful tool. In a more macro sense, I think that it's going to change the way a lot of things are done. If you're a teacher, and you give an assignment to your class about, write me an essay about Catcher in the Rye, or about, Farewell to Arms, all your students are going to have to do is go into their, Chat GPT or, Claude or one of these, Gemini, and prompt it appropriately and get a really nice report. Well, how do you know they did it versus, the AI engine? So they're going to have to assume that this information is now available. And the analogy I would give you would be when spell checking came along. And that's a kind of a silly analogy, but, up until then, teachers or courts or whatever would be very concerned about spelling mistakes. Well, spell check comes along, and there's no more problem with spelling mistakes. So that is no longer a factor where you're being graded on if you're in school, because there's no reason for spelling mistakes. It's all, spell check. I think with AI, it's going to be, how do you use AI as a way to enhance your learning? In the law business, how do you use AI to make a more compelling argument, or to find, the evidence you need? I'll give you another example of how I use it. I'll say to the AI engine, my client has been diagnosed with, what's the condition I was just working on today? I can't remember the condition, but it was it was a medical condition, and anyway, it was my client had a liver transplant. That's what it was. And so I put into the AI engine, my client is on the following medications, immunosuppressants and other drugs, because of his liver transplant. He's also diabetic. What are the implications of these medications on a person who's diabetic? Well, sure enough, the AI engine comes back and tells me that the medications he's on, tend to negatively impact blood sugar and make diabetes worse. And sure enough, my client had gone from a type 2 diabetic taking pills to insulin dependent. And then there was other issues that he had along with that he was in fact suffering from, nausea and constipation, all these other things. And the AI engine really helped me understand that. And of course, it gave me the sources. So I went and looked at the, WebMD and things like that to make sure it was telling me the truth. But, it just saves a lot of time. So I'm on a tangent there, but the bottom line is that I'm sure Social Security is or will be using it, as will disability attorneys and everybody else. So I think that, as Mark Cuban said on the Shark Tank one time, we're going to get to a point where the world's going to be people divided between people who you understand and use AI and people who don't. So you definitely want to learn a little bit about it when you can. Does PHP help with the depression case? What is PHP? Let me see if I know what you're talking about. PHP. There's a PHP, it says partial hospitalization program. I'm not sure if that's what you're talking about, where it's sort of semi-outpatient, semi-inpatient. Yeah, I think that would help, because anything, with depression cases, if you're treated with medications at home and you're not hospitalized, not going to, intensive therapy, it's perceived to be a little less serious. If you're, going to meetings or treatment on a daily basis and that you're in the hospital for 2 or 3 hours a day, that's obviously going to be a problem with working. So I think, yes, it would. Okay. Sheesh. I'm 52 years old, suffer from spinal stenosis, worked in construction, did get approved at 50, gave me great hope when I was unsure. You're welcome. Well, very good. I'm glad you got approved. And this is an example of a person who at 50 most likely got approved under the sedentary grid rules, because, long work history, spinal stenosis, most likely found not capable of doing more than sedentary work. Got approved. Inpatient as well. Yeah, I think that is very going to be helpful to you. Yes, I think that will make your case so much stronger. Yeah, I think, Russell, you're right. Be proactive, be your own advocate. Absolutely have to be. I'm an overpayment. I'm applying for SSD. Will it affect anything? An overpayment from a prior Social Security case. My concern here would be, if you get approved, they'll reduce anything you're owed by the overpayment. So I wouldn't wait to deal with the overpayment. I would deal with it now. And that would include bankrupting on it, because if you have an overpayment and you get approved in a new case, I think that what they're going to do is they're going to just reduce what they owe you by the overpayment. They'll take it out of what you're due. Okay. All right, so let me put back the other crawl here. Melissa is a consultant spine surgeon, doing a PT for evaluation due to insurance. Yeah, no, again, Melissa, you got a good case. I think you got a very good case. Sharon. Hello, Sharon. You're a new voice. Glad to see you here. Will recently applied for SSD. The interview said it will be reviewed in August. We'll get my first check in September. Well, if they're telling you you're going to get approved, yeah, that's a good sign. I've never heard of an interviewer telling you you're going to get your first check. Are you sure they didn't say, if you get approved, you're going to get your first check? But if they, I don't know that the interviewer really has the authority to tell you that you've been approved. In fact, I have people tell me they call up and they're being told, a decision has been made. This is after all the workup has been done. A decision is made, but they won't tell them what it is. So the idea that an interviewer, when you apply, is telling you that you're going to get a check, I wouldn't buy that. I wouldn't buy that. Look at that glowing skin. Okay. Somebody said that that's the person who said I'd lost weight. So I think they need to get their eyes checked, maybe. I don't know. Okay. Good, Sharon. I'm good to see you, first of all. And yes, we got approved. It was we worked for it. We worked for it. We worked for it. That's all I'm going to say, because you have a lot of evidence, and it was, I know you got really frustrated at times because of all the time it took, but it all came through, and I think you're right. I mean, I think that, when, and Sharon, had a very, very high level job, and, when you can't do that kind of work, or any job for that matter, but especially someone who's doing an intellectually stimulating kind of job, and you can't do it, it gets in your head. It's really, really frustrating. And so I think that's a thing a lot of people don't understand about Social Security, is that it can be, it's nice to get the check, but on the other hand, all of a sudden you're on an island, you're by yourself, and it's hard. It's really, really hard, just mentally. Wildebeest. Is it common practice for a lawyer not to cross things on a VE in a hearing? I think evidence speaks for itself. It really kind of depends. I mean, if I'm winning, I'm going to keep my mouth shut, because you don't want to pull defeat from the jaws of victory. If the judge asks the vocational witness one question, the answer is no jobs, I'm not going to ask any questions. If the vocational witness, comes up with a bunch of jobs, I would at least ask. I always have my own questions available, ready to go. So, I'm prepared to. I don't ever like to let a hearing go by where the only question asked is one by the judge that gets the answer, jobs, and I don't ask anything. At least if I ask a question, it's at least putting in some question in the judge's mind. The judge is going to rely on whatever question he or she wants to. My question is probably not going to move the meter. But every once in a while, I'll ask a question with some limitations that'll get the judge thinking, and, it might change the judge's mind. But so it's not unusual if you're winning. If you're not winning, it is unusual. How about that? Carrie, my husband was approved for SSD on December 27th. He will turn 62, and she expects to be called in for revalue. I don't think he will, Carrie. I just think that at 62, it's just not likely. Not likely at all. Abby. Hello, Abby. Well, welcome. Welcome aboard. I'm glad you are a subscriber. Thank you for subscribing. Much appreciated. Rajul Hoke. I'm 36-year-old, schizophrenic and back pain. At my court hearing, the vocational expert had 3 jobs, found 3 jobs you can do. But then there's the off-task question. It's going to depend. I can't really answer that, because judges will typically ask 3, 4, 5 questions. One of them might include the off-task, part where you're off-task 15% of the day. The judge is going to choose one of those questions as the basis for his or her conclusions and his or her assessment of your RFC. So just because, in other words, if the judge, if your attorney asks 4 questions to the VE and each one of those gets no jobs as the response, yeah, that's great. But if the judge is going to rely on the question he asked and the answer came back with 3 jobs, you're still going to lose. So it just really depends on, the question the judge asked, and, is there evidence to suggest that, you would not be very reliable and be off task as much as you were. Michelle, good to talk to you and Mike today. Yes, I look forward to working with you. I sent you an email a few minutes ago, right before I jumped on here, basically saying that Madeline will send you all of the paperwork to sign. But it was great talking to you and Mike. I know I had to jump off. I think I was telling you my daughter and my wife were going to a yoga class, And so they wanted me to watch my grandbaby, or she's 22 months old. She's not a baby, she's a toddler. So my wife walks in my office here with my granddaughter in tow, saying, "Okay, she's yours." And I was talking to you. I'm like, I got to go because I got a toddler here who's going to rip my office to shreds if I'm not careful. So I had to go. But I appreciate your patience with that. I'm glad. I think if we have any questions, you of course let me know and I'll call you back. But we're in good shape and we got a good case, I believe. There's a purple O next to your name. Huh. I don't see it on my what I'm looking at. I'm just seeing a P and at the YouTube symbol it says Pricey Joyce. I don't see that there. At the top of the screen, there's a purple crown with 50 XP by it. I'm not seeing that. Now, again, that may be in the YouTube feed. I'm looking at this. I use a program called StreamYard, which does not show me the YouTube feed. So it's just showing me the feed from this. I can try to log on to YouTube and see if I see it here. Let me turn the volume down because now you got me curious here. And we've got a couple more minutes to go anyway, but now you got me curious here. Oh, and I'm at 80,000 subscribers. That's kind of cool. 80,000 subscribers here. Okay, so we're looking for all these anomalies here. Okay, I can't see it because it looks like it's live here. So I can't see it on YouTube. Oh, because I got the wrong channel here. Okay, let's try this one. Let's see if I can. I don't want to waste everybody's time with this. Now you got me curious about it. Let's just see here. So I am looking. Okay. I'm looking at YouTube. I don't see anything there. So I don't see anything there. So I'm just going to close that out because I don't want to create all kind of problems here. But anyway, I don't see anything there. So I don't know what that is. Maybe I can't answer that. Okay, so we got time for a couple more questions here. At my SSDI hearing on April 9th, I'm 54, 6 months from 55th birthday. We've been graded at 50, 54. Sometimes I've seen judges use the grid at 55 for a person who's 54 months and 54 years and 8 months. At 54 and a half, I don't know that they're going to bump you up to the next grid. Maybe. I doubt it. It could happen, but I kind of doubt it. I think it's too far away. The crowns are next to some of your names. The only thing I can think of is maybe you have a YouTube, you've uploaded some YouTubes and maybe you're seen as being some enhanced YouTube user. I don't know. Do you have YouTube TV maybe? Yeah, I don't know. I mean, I don't know. So it's an interesting question. I'll look at the playback and see if I can figure that out, but I don't know. Okay. So this talked about leadership board. Okay. So what Russell's telling us, if you see a little crown, it means that you've had a lot of comments, which is always great. I love the comments. And so they must be some sort of it says leadership board. So I don't know. I've never heard of that, but that's okay. That's great. It seems to be a new community leaderboard type of thing. Gives you extra. Okay, so those of you who are answering questions for others get a crown. Hey, that's kind of cool. I didn't know they did that. That's really kind of neat. Thanks, Madeline. I did not know that. Okay, we got time for just a couple more questions. I know there's a bunch more people here, but I'm going to try to zoom through 47 minutes, same jobs, 15 years. Hashimoto's and Sjogren's, sick, kicking my butt with pain and exhaustion. I can retire in 8 years. We'll see if I can make it. I think if you can get to 55, life will be easier in the Social Security world. Certainly get over 50. I think winning at 47 is really going to be hard. It's just going to be really, really hard because these are Hashimoto's is not that unusual. These are both conditions that are hard to quantify, as it were. And I think that, yeah, I would probably tell you try to get to 55 if you possibly can. Okay, well, good. I'm glad, Carrie, that your question, I'm glad it was helpful. That's what I'm doing these things for. So, okay. Trial work period is gross income. And yeah, I would agree with that. Okay, Mark is a community work incentives coordinator. Okay. Well, Mark, then you know better than me, I suspect, that it's gross income and no deductions. Because somebody asked about deductions for, sick time and things like that. So I think we've got an answer on that. Okay. Abby Kennedy was diagnosed with chronic kidney disease, stage 4, congestive heart failure, 2 heart attacks, also have peripheral neuropathy. Why denied? I have no earthly idea why you'd be denied with all that. It's just Social Security makes it really hard. I don't know how old you are. I don't know, maybe they didn't get all the records in. Maybe there was no discussion of the functional implications of all that. But I think that you sounds like a pretty good case to me. Jody Mitten, how does chronic hypoxic respiratory failure and oxygen reimbursement get SSI under age 50 with cold? Yes, I think it would. I think if you're in oxygen 24/7, that is COPD. Yeah, I think that's a winning argument there. Chantet, I'm 49 and a half, been waiting reconsideration. I would like to know when I get the answer. Reconsideration 8, 10, 12 months, typically. Okay. Thank you, Mark. It's $11.60 a month gross for 2025. Yeah, again, now I've got all these figures written down, and I just, I don't have them all memorized because SGI I know pretty well, but trial work period I don't really deal with very much unless somebody asked me about it or I was doing the seminar. Okay, let's see. I'm going to do 2 more questions. Carrie says, Carrie, my client, does SSDI back pay all the way back to onset day once you're approved, no matter how far back it is, after the 5-month waiting period? Well, if you only get paid 1 year prior to your application. So the 5 years, the 5 months can run before that. So, you could, let's say that you got approved, your onset was 2 years ago. The 5 months runs the first 5 months, but you don't get paid until 1 year prior to your application date. But the 5 months can run 10 years ago. Doesn't matter. But the payment is only 1 year prior to the application date. Okay. Sharon, when does trial work period officially begin after approval? What if I work some waiting? I believe, and this is a point in the seminar. It can apply before you are actually approved. I believe it is the later of the onset date or date of application. I believe I don't remember exactly which one it is, but it can apply before you're actually approved. And the 5-year rolling time frame is still, so in other words, the 5-year rolling time frame is they're looking at, when you are using your trial work period service months, it's a rolling 5-year period of time, and every month one rolls off. But I believe it starts as of your onset date. And if you're working as of onset and you work 9 months after onset, then you could use them up right then. And how do you don't really initiate it, you just have to report it using your My Social Security. You know what, Sharon, I will send you the PowerPoint and the materials from the trial work period seminar I just did, because I think I've got all the stuff in there. I'm going to probably enhance it, but I'll send you the materials anyway, just because I've got them sitting right here. I'm literally on the floor where I printed some of the stuff out, but I just hadn't organized it for a YouTube presentation, but I will. Okay. All right, so I'm going to answer this, and then we'll be done because it's already 2 hours. All right, Jane Solis, I'm in recon, right, with me. Okay, post-chemo, 2 times cancer now, 300 pages of new records, very expensive to fax. How do I send to you? I would, if you can scan them, that's the best way. We do everything, we scan it. So if you can find a scanner, just scan it into PDF and send it to me electronically. That's the best way to do it. Or if we can download those from a portal, then we'll get them. So I would ask Jen about that. Let's figure out a way to get those records without having to deal with 300 pages, because I'm sure they're available electronically, either through HIT, Health Information Technology, or through a portal. But that would be a question that just send an email to Jen, and she's probably still watching, and she'll reach out to you, and we'll get those records in. Okay. All right. It is now 2 hours, so I am going to be done. I appreciate everybody's questions, and we'll see you again next Wednesday at 8:30. I appreciate your joining me, and I wish everybody a really good night. Thanks a lot.